Hey everyone, welcome to another episode of Darshan Talks. I'm your host, Darshan Kulkarni. It's my mission to help you trust the products you depend on. As you know, I'm an attorney, I'm a pharmacist, and advise companies with FDA-regulated products. So if you think about drugs, wonder about devices, obsess over pharmacy, or as my friend here today, my guest today does, consider cannabis. This is a live stream for you. I do have to emphasize that both of us are attorneys. Neither one of us are your attorneys necessarily. And I am a pharmacist, but I'm not your pharmacist. So this is neither legal advice nor clinical advice. But we do these because they're a lot of fun. And because I personally find myself learning something new every single time. So it would be wonderful to know when someone's listening. So if you like what you hear, please like, leave a comment, please subscribe. If you want to ask our guest questions, please feel free to do so. Just type it in. We can see them, and we'll try to answer them if we can get to them. If you actually like the interview itself, we'd love for you to actually share it. And you can do that on Twitter. You can do that on LinkedIn. You can do that on Facebook. And you can always find me after the fact or even during on Twitter at Darshan Talks, or just go to our website at darshantalks.com. Today's live stream, today's interview is actually kind of fun because we're going to talk about something that my guest today does all the time. And as she put it, she is in the APAC region, the Middle East, North Africa. Even though she has a bunch of US clients, she seems to be working continuously on global time zones. I remember that sounding so fancy when I was in law school and when I was in pharmacy school. And now all I can think about is that sounds really painful. And that sounds like a lot of fun. And yet I'm just going, I've done that, and that's just more power to you. So if you are an international player, you're working at the global level, you have questions about trademarks, you have questions about branding, you should be talking to us about these questions. And our guest today, I do want to emphasize, is a partner in the Philadelphia office of Duane Morris LLP. She's the team lead for the firm's fashion, retail, and consumer branded products industry focus group. Our guest for today is Christy Campbell. How are you, Christy?
I'm great. Thanks for having me.
It's always good to have you on. We always have such a fun time talking.
We do. The conversation's unpredictable.
I'm always enjoying this because I was asking you earlier, like, what you're involved in nowadays. And you actually mentioned to me that you're obviously doing all this at this global level. You're working all over the world, but you're still prosecuting and sort of negotiating and engaging in these copyright lawsuits. I'd love to sort of get a little feel from you on how do these lawsuits begin? Let's begin with let's start at the beginning. What is a copyright? And then why do people care? And we'll go from there.
Okay. Copyright in the most general sense is protection over, it's a bundle of rights. Any law school professor will tell you it's a bundle of rights afforded to the creator of an original work of authorship fixed in a tangible medium. So the way that I know that we've talked before about how to differentiate between patents, trademarks, and copyrights, and the way the US government has it set up, you really have to give something. You have to have something before they'll afford you any level of protection at the federal office level. So copyright really gives the author and the owner of a copyrighted work the ability to publish, to adapt, to distribute, to perform that particular work. So typically, and I like to give examples, an example of a copyrightable or copyright work would be a screenplay, a book, a work of authorship, photographs, art. Yeah, I'm looking at Captain Marvel. Yeah. So obviously, a lot of IP there, in addition to the brands, there's copyrights. Copyrights exist from inception. So from the moment that the creative work is fixed in that tangible medium, interestingly, the Copyright Office, we refer to as a dinosaur, because if you want to pull documents there, you're looking at microfiche, which I'm dating myself, but I haven't looked at since I was in like third grade. But the Copyright Act is actually very interestingly fluid and fixed in a tangible medium. It's interesting to me because it from early on when the Copyright Act came about, you may have had paper and things like that. Now you've got, you had discs, and now you've got electronic means. So in a way that affords some flexibility to the way that copyrights can be protected. In addition, software code, object and source code are protectable through copyright. So circling back, copyrights exist from inception. However, recordation is possible with the United States Copyright Office or the Library of Congress, and indeed necessary to have a copyright registration before you can sue for copyright infringement in federal court. There is the possibility that a copyright claimant could retroactively file an application, ask for expedited registration, use that as their ticket to get into federal court, and that would affect the damages analysis. So that's copyright in a nutshell. You look at companies like Marvel, and again, I'm looking at the poster behind you. There would be likely a huge portfolio of different copyrights, because you'd have screenplays, you'd have drawings, progressions, and then a licensing program for all the merchandise, and that ties into branding as well. But yeah, so copyrights are important. We talk about trademarks a lot when you and I talk, and trademarks are territorial. Copyrights through the Berne Convention may have a little bit more international scope. I don't want to get too much in the weeds there, but whereas with trademark rights, you really need to have either use and or registration in a particular jurisdiction. Through the Berne Convention, you might be able to use a U.S. copyright to enforce rights. And we've successfully done that in China, used U.S. copyrights to enforce rights in China.
How does that play itself out? Because one of the things I've heard is that enforcement, I know for a fact, for example, in the Indian authorities are very big on actually passing laws. It's the enforcement that you have a major issue with. So which really makes me wonder, well, what's the point of passing a law if you're not going to enforce it? But I've always heard that China tends to favor the locals, and I understand the thought process behind it. How do you enforce your copyrights in a place like China? Are they open to it? I know the most famous ones I've heard of is the trademark issues, but Michael Jordan having a really hard time with his own name in China was the big one. So I'd love to hear some commentary about that.
That's one of our favorite cautionary tales, because I actually work very closely with the law firm that did the work for Michael Jordan. And that is like the quintessential, it's the story I go to when clients are a little bit hesitant about filing for trademark protection in China. So again, using kind of a real world example, a little anecdotal evidence of how a copyright might work in a client's favor. In China, I worked for a very well-known state university. If you happen to be in Pennsylvania, you probably know it more well than other states. And they were having issues getting, there was a third party in China, a local in China, that registered the university's logo for itself and registered it for all sorts of merchandise, all the types of things that you would think would come from a major state university: sweatshirts, t-shirts, hats, shot glasses, keychains, you name it. This pirate in China went out and registered this very well-known logo for all of those things. So when we went to enforce this state university's rights in China, we came up against a stone wall that was this other party, and we were having a hard time getting the registration back from this other party because in China, it's a first to register jurisdiction. So the first party to get to the registration stage with a trademark is the first in right. So use doesn't really matter. And in addition to use not mattering and having common law rights that might trump a registration, there's no requirement to have a legitimate right to use or actual use. When you file an application, you can obtain a registration with basically no standing is what I would say. So this party went out with absolutely no legitimate rights or interests, registered this very famous logo, and our client realized that if we didn't take action and basically get it back, 80%, I think, of their merchandise was coming out of China. The manufacturing that they were doing was coming out of China. And if this third-party pirate had gone and recorded the client's brand with Chinese customs, our state university clients' own legitimate merchandise would not have been able to get off the docks in China. So that would have been a major blow to their merchandising. We came up against insurmountable hurdles with the trademark issue. And one of our Chinese associates recommended filing and getting a copyright registration here in the United States and getting corresponding copyright protection basically to push through in in China. And because the copyright went back to the publication date here in the United States, which was in something like 1983, we were able to demonstrate in China that this other party, that we had prior rights, and this other party must have acted in bad faith because they had to have known about us. It's a little bit of an unorthodox approach, but sometimes in China, you've got to get creative. So that is how copyright protection here in the United States actually worked to our benefit in China when the trademark aspect of the case was not going our way.
So I mean, just the conversation we've had so far has so many different questions. Let me start with some of the basic ones. The first one, you raised this idea of squatters and essentially people with no legitimate interest trying to take over something. What has been your experience with people trying to demonstrate squatters' rights, for lack of a better term, over things like URLs? I know I'm going into trademarks theoretically, but I'm just curious because I've seen that happen where I think it was, I've heard, again, going back several years at this point, but people basically taking over very well-known trademarks and saying, I own this URL. And now the company that actually legitimately should own it is boxed out. You obviously have dealt with this situation more than a few times because you've got this big smile on your face, which is either PTSD or or just something you know really, really well. So I'd first love to get your comment on that before we go on.
Yeah, I guess like my response to your last question, that opens up so many different issues. And it would be PTSD, but I've had a high level of success with the domain name disputes. So what happens with domain name real estate is squatters very early on kind of seized on opportunities and registered domain names that incorporated famous names. The Uniform Domain Name Dispute Resolution Policy, it's favorable to brand owners, truly. The burden of proof and the threshold for a domain name owner to go after a squatter is high. It's almost like filing a summary judgment motion. You've really got to have all your facts lined up. You've got to show that you have legitimate brand rights, with or without a registration. It can be through common law if it needs to be. That the third party pirate has registered the domain name incorporating something confusingly similar to those brand rights, and that the domain name was registered and is being used in bad faith. And you've got to have all four of those prongs. It's the last two that really can hang up even legit brand owners. There are things like fan sites, political commentary sites, parody sites, things like that. Those are actually constitute legitimate fair use of a particular brand. So if it was like a gripe site, not much we can do. I will say the domain name work and domain name dispute work, it's still there, but it has largely slowed down in the recent past with the, kind of the growth of SEO and the importance of SEO to clients. So I'm able to say to clients now, like, look, okay, let's take a tiered approach, and let's say, okay, this third party has your brand in their domain name. They're not coming up in a Google search. They're not posting anything negative about you, which would be another problem because we may not be able to do anything about it. It's not a phishing site. It's not a scam site. And is it causing a harm? Is it a no harm, no foul situation? Because having the domain name real estate is really not as important anymore if clients are coming up first in a Google search. And that's SEO. So, no longer are people typing www.clientname.com into their browser because there's just too many different things it could be. And one of Alexander Watkins, one of my favorite brand naming experts, talks about this. Look at what your domain name says and don't make it hard to spell, don't make it hard to find, but truly it's Google or Bing or Yahoo, but let's face it, Google is how people are finding websites. So I'll say to clients, look, we could go after yourname.com, but they've been using it for years. There's probably not much bad faith there. Maybe there is. We're going to have to file this, basically summary judgment motion, the NAF or WIPO. It's not that expensive, but it might be more than they want to actually pay for a domain name. Yeah. But I'll say to them, look, if this party isn't causing any harm, they're not coming up in Google, just, register something else and make sure your SEO is up so that you're the first search result when people look for your name and a couple of different search terms. So that's kind of a way that I don't even know that it was intentional, but the pirates are less able to capitalize on having that prime domain name real estate. I just talked to a client on Sunday night that told me that they paid a figurative arm and leg for their name.com domain name because they couldn't have taken it forcibly through a UDRP. They didn't really have those 4 prongs. And what they paid, and this was like 20 some years ago, they would never pay today because they put that money into SEO.
Right.
Yeah.
So I mean, that raised a couple of different questions to me, right? What does bad faith mean? And one of my favorite ones is one of the famous billionaires from New Zealand is, I think he's something.com. I think he changed his name to .com, if I remember correctly.
Yeah.
Which I thought was interesting. But what stops me from changing my name to Microsoft and then trying to take over www.microsoft.com, alleging that I have now legitimate interest because that's my name? So I'd be curious what your take is on that before we go into like the next question.
Yeah, the hypothetical doesn't work because if you're changing your name now, that's probably your bad faith act, right?
Fair enough.
Bad faith can come in any one of a number of flavors. The UDRP itself has enumerated, ways to show bad faith: phishing, scamming, asking the complainant for more than out-of-pocket costs associated with registration and maintenance of the domain name, asking for exorbitant amounts of money, extortion, and passive holding. So just having a domain name. One way I've shown bad faith registration and use is when you click on a particular, domain name that might be held by, say, a pirate or, cyber squatter, as we might call them. There are sometimes just links to click on. And if those links, like the client of mine I just mentioned, we just won a UDRP for them not long ago. They're a furniture company, and the links were to different furniture companies and actually some of our clients' competitors. So for me to be able to show bad faith before the NAF, I said, look, these people are capitalizing because they're getting pay-per-click links, and they're making money every time somebody goes to their website thinking they're finding my client and clicking on my client's competitors. And this domain name registrant is getting a cut every time there's a click on those links. So that's bad faith use and registration. And it also, there's a tinge of willfulness there too, right? Because they're obviously aware of my client, its brand, what it stands for, and they're using that as a way to get, the pay-per-click links, even though they're not associated with these other competitors necessarily, other than, having the links and getting the money. So one of the challenges I've had with some startup clients actually is they start their business, we clear the name. I kind of work from the bottom up in terms of domain name clearances and name clearances. Common law uses anymore are really critical. You're more likely to have, maybe not more likely, but you're very likely to have an issue if there's a common law use of your name. It's not so much what's on the trademark registry, either federal or state. So you got to really look at like what's on social media, what are the handles on Twitter, Instagram, whatnot, because there's brandies out there. So an issue we've had with startup clients is they come up with a name, we clear it, but that name.com is not available because somebody else has it. Right. The problem is there's a priority issue there. And the somebody else that has it may have actually registered the domain name before our client decided on its name. And so it has to be bad faith at the time of registration. It's never fun for a client that, theoretically clears its name to find that name.com that was registered back in
1992, right,
by Mr.com, because
right.
That's what they did. And then they're, that party's probably going to hold it hostage because they're not doing anything with it. And they say, look, I could make this money on the pay-per-clicks, or I could sell it to this legitimate brand owner who clearly has a major stake in it, and they'll pay me hundreds of thousands of dollars for it. So sometimes we'll use a third party to go out and try and acquire the domain name on like a non-attribution basis, but it's hard to do that because it's pretty obvious who wants your name if you. It's like a running joke, like go on a non-attribution basis, like they're not going to know who you're representing.
So let me ask you this question now. we've talked before about trademarks. We were talking a little bit around copyrights, and then we got into this idea of ownership and domain names, which is not truly hardcore a trademark right, or at least I would assert, and you'd be the one to tell me if I'm wrong or right. But do you see, and this is sort of a philosophical question, do you see new rights emerging that were not contemplated for? And what I'm referring to are these domain name rights. Or I was thinking about, is there, for example, a right in showing up in a specific location in a Google search? Should you have that right? Or is it we are tied by the Constitution to certain types of intellectual property, and that's all we get? So what's your take on that?
Man, we could talk about this for days. So the domain name rights, interestingly, they're just a reservation, right? Like you don't actually have title. You're the registrant. They're like phone numbers with the ICANN, International Corporation of Assigned Names and Numbers. So it's almost like a leased space. However, if you are the name registrant, you're the party that has it in your registrar's account. You're paying the maintenance. You're paying for renewals, probably auto renew. And you're most likely going to put up your domain name portfolio as an asset, a scheduled asset in your IP disclosures. If you are selling your company, if you're doing a due diligence, whatever it is, they're looked at as an IP asset. Right. I perform due diligence on them just like they're any other IP asset. I look at the title, right. Look at whether it's functional, look at if there's any third party issues. Interestingly, it kind of works in the reverse. So there is a tie to trademarks. I mean, Anti-Cyber Squatting Act, it's all tied to trademarks and unfair competition. And the reason is, I think, typically it's the trademark or the brand of a particular party or claimant that is the subject of a domain name, or is at least incorporated in a domain name. So trademark rights almost lend themselves. The reverse of that isn't true. The mere use of a URL or the mere reservation of URL is basically like a business name registration with a Secretary of State. It does not bestow upon a party in and of itself any trademark rights, because it's not really a source identifier. We could argue about that all day long, but this is what the law says. It is not a source identifier. It's a phone number, it's an address. It gets you there. But unless you are, and I actually had a case about this last year before the TTAB, unless you are using that domain name as a brand and a source identifier. So in your advertising, does it always say www.yourname.com? Is it really a stand? And booking.com is, and hotels.com. So I have a feeling that's where you're going with this. And there was a slew of like client alerts and attorneys speaking about, oh, you've got to register everything.com now, because people could reverse back their way into using generic terms. No, not what the court said, not what the law says, but we will. So when it comes to a client registering a trademark, typically the .com is not part of it. It's extraneous material. It's not going to be a part of its registration. It's not what it's using as a brand. And typically their actual brand use is, a little bit separate from, not a little bit separate. It's totally separate. They have actual brands that are used without the .com. The brand is popped into the .com. But it is a trademark right that they would assert in that UDRP complaint that I was talking about. It's very clearly a trademark or business name right that you would assert to try and take that away.
So what I'm hearing, and what about something like position in a Google search?
Mm-hmm. So
go ahead.
So
again, it sounds like PTSD, but go ahead.
Google, no, it's not. Google searches, like keywords and AdWords, is a place that is it's incredibly frustrating for clients because, at least in the United States, competitive advertising is allowed, right? So it is technically okay to have competitors' names in your metadata that might drive search results to, not the party they're searching, whatever. There's like theories of it. Again, we could go for months. It could be a whole curriculum, a trademark class in law school. You could talk about initial interest confusion. You could talk about whether it's actual brand use, all these like trademark axioms come into play. And with Google search, like, of course, you're going to have in your metadata and your keywords, AdWords, your name. Problem is you're going to put your competitors' names in there too to drive traffic, and you can to a point, as long as you're not doing it in a way that creates consumer confusion. And it's, whose confusion as to what. But I think I think the way the law, where it is right now, if I am looking for the Ford website and I put a couple of like search terms in, and a Chevy website comes up in my Google search results, I'm not really confused. I might be led astray. I might get distracted, but I'm not confused. I mean, even the most ordinary consumer would not be confused. It certainly is something that I will put into my arguments and evidence in foreign jurisdictions if I don't have a registration and I've got to show either significant use or renown of a mark to kind of trump registration rights that I don't have for a client. And one of the things I will do is say, look, if I'm sitting at a desktop in India and I want to find the client and I type into Google, this is what pops up. It's the first one on the search result. My website's viewable from there. I can purchase. The product can be shipped to India. So those are kind of, and I use India, but we've done it in a number of different jurisdictions throughout the world where we're trying to say, hey, consumers on the ground in this jurisdiction are aware of this brand just because we don't have a registration here. And because consumers are aware of this brand, so is likely the opportunist that went and tried to register it without any authorization or rights to do so.
Which is so interesting. So I'm going to ask you another question. I feel like we sort of just built off of the conversation itself, which is what we always do. But I've been sort of, and I'm sorry, we've done this more around trademarking again because I find trademarks fascinating. But we talked a little bit about this poster back there on Marvel, and I've sadly found myself going down the Facebook Marketplace rabbit hole, and I've been looking at random things that people are selling. The thing that always jumps out to me is when you see local artists try to sell their drawings of Marvel pictures or like superheroes. I'm curious, that falls sort of into fair use, but when is it, and I recognize the fact-specific inquiry, but when you're trying to advise large companies, it's very clear that you need to license some kind of license from Marvel or whoever. But if you're advising a individual artist, what are the limits of fair use for them?
It's a really good question because you've got trademark rights at play, and copyrights at play.
Yep.
An artist's rendition of a Marvel character, and there's just a minefield of issues that could come up, and it's a sliding scale, and it could go any one of a number of ways depending on the exact scenario. So selling on Facebook Marketplace, you're walking into commercial use, and that is where Marvel is more likely to have a problem. Okay, so it's your business venture, and this is what you're doing. More likely to be problematic for Marvel. And if I'm advising a client on the ownership side, and they see a small artist doing a particular thing that offends them or could potentially take business, it's really going to be, okay, does it cause you competitive harm, and does the harm justify the protracted litigation and expense of going after a party and having to make your case, or is there another way to address this? On the artist side, it's not always going to require a license. And a lot of people will not go out and look for a license from Marvel because, number one, they probably don't know how to. Two, they know they probably won't get it. This happens a lot with music too. Smaller businesses want to use music in their advertising and want to be able to do that. And it's like, well, do you really want to go through with contacting ASCAP and BMI and getting the license and blah, blah. So there are so many different rights at play, especially when you talk about Marvel, right? If the artist is selling, that exact poster, even if they drew it themselves, likely that's a reproduction distribution, dissemination. That goes back to the copyrights that only the copyright owner can exercise that bundle of rights they get by virtue of the fact that they are the artist, they are the creator, whether it's by work for hire, employment, or otherwise, and they fix it in a tangible medium. So the poster behind you is very likely owned by Marvel. The copyrights in that poster are owned by Marvel. Marvel is a business. It's not an artist. It's not but the person who created it for Marvel very, very likely has an employment agreement that has work for hire language in it and a fallback assignment provision in there so that Marvel can assert ownership. And it would be likely an infringement of the copyrights that Marvel has to copy that poster exactly, especially if it's for commercial purposes. I have represented smaller artists that do things like murals and do comic book characters and superheroes and put their own spin on them and their own creative spin. And that actually is a whole other area of the law. I mean, this has been done in museums in New York City where people are taking other people's Instagram posts and photos that someone owns the copyright in those, but they're putting them in and using them in a new way. And that's actually called transformative use, which is a theory of fair use. It's a transformation. It's using it a different way. So if I was to take that poster and put my son in there or my niece in there and have, instead of flames, like softballs coming out of her hands or something, that would be probably transformative. If you're fighting with Marvel, it might be less likely transformative. But point being, that's a way of getting around infringement. Parody is another way, but parody, you and I have talked about parody before, and it is, a lot of people think that just because they did something and they, it's funny, it's parody. Yeah. It's not. You have to be parodying the thing that you're parodying. So,
so it can't just be funny. It has to be tied to the actual.
1000%. It has to be tied. You have to be giving some parodying commentary, like if it's political, social, whatever it is. But yeah, it can't just be, those are lassos coming out of her hands and that's funny.
Let's regardless of your political affiliation, if I put Donald Trump or I put Joe Biden on there, would that be a parody?
I think
I'm really hoping you don't.
Colorable argument. I'm not talking politics here, but I think there's probably a colorable argument among a lot of people that making Donald Trump a superhero might be a parody. Because honestly, again, I'm no political commentary here at all. What you could say, which any Republican or Democrat will agree with, is he's an egomaniac, right? So him putting himself in the position of superhero, I'm above all else, I'm above the earth, nothing can stop me. That's political commentary. That's a pretty solid argument for it being a parody.
So it doesn't have to be tied to the fact that it's Marvel. So you don't have to necessarily have it be about Marvel. It can
not
be
really. Okay. Not really. Okay, no. Okay. I mean, it's again sliding scale. And it's probably easier and more direct to say, okay, well, Marvel, and I know it's had its I don't remember if Black Widow's Marvel, right? So them having issues. So if it was Scarlett Johansson's camp, showing Marvel instead of Brie Larson there having, Marvel itself as a business or its CEO, whatever. We are high and mighty. We make the decisions. That might be social commentary. If you're going to put Joe Biden there, I just don't really know what. It doesn't really make sense.
What's so funny about it?
Or what is it? What is it? Yeah. I mean, I'm sure you could come up with a lot of people actually, interestingly, come up with the reason it's a parody after they're accused of infringement. So well, I thought it was parody, but I never really thought about what I was parodying. So I better come up with a good parody excuse before. So that's, parody's an interesting area of the law. It's not easy to argue.
So we have a question, by the way. If the artist gets permission to adapt and acknowledges the original copyright owner with that work, I would argue that the fact that you got permission sort of supersedes everything, right?
Exactly. And permission, again, a lot of people won't ask for it because it's maybe I'll just ask for forgiveness instead of, ask for permission. That's a very good question. Getting express permission would, in the most literal sense, be a license. And it's a copyright, probably a copyright license here. It might be a trademark license depending on how you're using it. But the copyright license, again, the copyright owner has that bundle of rights, and they have the ability to license those rights for limited purposes. However, they control is actually a really, really important, in fact, critical aspect of trademark licensing. But the copyright owner would be able to grant express permission. They might put in that license a specific provision saying, you've got to have attribution here. There is a very common misconception, I would say, especially among social media users, that if you give attribution, you can't be on the hook for copyright infringement. And that's not actually true. There are a lot of instances where, if you're giving attribution and you're tagging somebody, the way that social media works, a lot of people are going to be like, well, fine, that's more followers for me. It's more likes for me. Right. And they're okay with the attribution aspect and getting kind of the publicity out of it. But very technically speaking, giving attribution does not absolve you of copyright infringement.
So it reminds me of the arguments you make when you're in school, which is as long as you make a reference to where you got the source, then everything's okay. And in the real world, that's not what happens.
But not if you plagiarize, right? Like giving attribution is not it doesn't forgive plagiarism. Okay, it gives credit because you're taking small snippets and you're stringing your own ideas together. I mean, there's age-old copyright law. I think it's Feist, but if you wanted to look it up, but it's giving copyright protection over a phone book because of the selection and arrangement of the numbers and names. You don't get rights over the numbers themselves. You don't get rights over the names. It's your selection arrangement.
That is Feist.
That's crazy. So copyright, very specifically, I should have started off talking about this because you asked me what it is, and I told you what it does protect. What it does not protect is, one, ideas. It does not protect ideas. You have to have something fixed in a tangible medium. Two, it does not protect facts. So, I mean, that makes sense, right? But if you're just reciting facts, you're going to have your own creative, and it's a very low threshold for creativity, a modicum of creativity. I think it's a scintilla is the very old judge's word for it, but scintilla of creativity.
Peppercorn of creativity, yes.
Yeah, right, exactly. Some judge somewhere came up with it, but it's very low threshold. But facts themselves not protectable. So that kind of circles back to, if you are copying something that's actually protectable through copyright, and it's not transformative such that you're creating your own new copyrightable work, permission is a way to go, because you get you've got a license, and it's going to tell you what you can and cannot do, essentially.
She is responding that simply attributing is such an issue with individuals reposting. Better claiming it as your own. But glad you pointed out that that's not enough. So that was one part. Here's an interesting question, though. So theoretically, if someone comes to me, and this is something I imagine you've dealt with in 100 ways, and just to be clear, I am usually, as you know, aiming for 15 to 20 minutes. We're at 40 right now, so I apologize. It's just super fun.
Always happens. It always happens.
It does. I love these conversations. But let's say I was looking to to write a book, and someone comes to me, and I imagine you see this with motion pictures all the time. If I was looking to write a book, someone comes to me and pitches me a concept, and I'll end up writing the book, but they've never written anything down. I'm the one who writes it all down. Do they have a copyright in the idea, or is that what you meant by you don't own a concept?
That's exactly what I meant. So I and I forgive the reference because I'm old, but there's a scene in the Muppets Take Manhattan where like Kermit is in a booth, and on the other side so I always envision like these guys sitting in a cafeteria booth thing talking about this movie they want to produce, right? They're talking about it, they have like the plot line, whatever, and Kermit's on the other side, and he overhears it and runs with it and writes the screenplay and produces the movie. Kermit gets everything because he fixed it in the tangible medium. The ideas are not protectable. So you get these crazies, forgive me, but they're crazies. They come out and they say, I'm the one who had the idea for Harry Potter, and J.K. Rowling just wrote it down. Okay, well, good for her, because she wrote it down. Like, it's great you had an idea, but that is how the law is set up around patents, trademarks, and copyrights in the United States, is you have to give them something.
Right.
Patents have to be reduced to practice, trademarks have to be in use in commerce, and copyrights have to be fixed in a tangible medium, or the government will not bless your rights in them. And it is to prevent this, like, well, that was my idea. Well, could you imagine what we'd be like if I have a lot of really good ideas too, but frankly, I have not had the time to sit down and write the manuscript. So someday I'm going to watch my $1 million book contract go to the person who actually had the time to sit down and write my book.
Right.
It is.
I'm going to ask one last question, by the way, and you have one more comment. Love the Muppets reference. Credit goes to the person who did the work and took it off the market.
That's right.
So one last question, which is one of the things you mentioned was that the copyright office or TTAB are completely overwhelmed with the amount of work that they have, and they're operating at with age-old microfiche, if you will, which is ridiculous. My question to you is, in the FDA world, you have something called PDUFA. Have you heard that term before?
I have not.
Okay, so PDUFA is the Prescription Drug User Fee Act. There's also MDUFA, BSUFA, blah, blah, blah. But the point being, industry says, we will give you money, FDA, to have the resources to act quicker. So it's the same as going to going to the DMV and saying, I will pay a fee so that someone can test me. Obviously, this causes a lot of consternation. I believe Russell Brand came out yesterday, the day before, saying, I can't believe that the pharma company pays the government. Obviously, that's a bribe. And I argue, not quite. But ignoring that part of it, is there any movement around having basically industry or whatever pay money so that the agencies have more capability and therefore can give better service, if you will?
So, I mean, obviously they'll have a PAC, right? There's a political action committee. There's lobbying on either side. Mm-hmm. I do want to distinguish between the Copyright Office and the Trademark Office because
sure.
I joke about the microfiche, but it's the Library of Congress, and there's actually some authenticity to the fact that there's a library. It's a library, and when I want documents from there, I have a runner go to the library and copy them for me, and it's microfiche. There's some electronic. Sure. I don't know that the Copyright Office is necessarily overwhelmed, because if they had the electronic system that the Trademark and Patent Office has, I think they'd probably be underwhelmed. It would work so much more efficiently. Another major distinction at the Trademark Office, at least the examining attorneys, are attorneys. Copyright Office, they're not. Patent Office, they're not. They're examiners, but they're not necessarily attorneys. The Trademark Office, you're being reviewed by attorneys, and they think like attorneys. They also think like traffic cops sometimes. But so, there are ways. Look, at the Copyright Office, I think I mentioned it early on. Your ticket into federal court in a copyright infringement lawsuit is a copyright registration certificate. They don't move quickly. They are a dinosaur. If you want them to move quickly, there are ways that you can spend an exorbitant amount of money to have an expedited application pushed through. It doesn't guarantee you. There's no favoritism other than you get a registration more quickly, and your registration is from the filing date anyway. So you're going to have the same date stamp. It's just obtaining that ticket quickly. Trademark Office, there's petitions to make special. I've filed one once in my life, probably wasn't granted. The rule of thumb with the Trademark Office is, like, if they can make money off of something, they create like it's rare that something in the Trademark Office dies if there's a way to pay to resurrect it. Okay, let's put it that way.
Right.
True story. So I don't know that there's necessarily like any lobbying around moving faster, other than the Trademark Modernization Act, which is going to come into play. Well, I say it's going to come into play the end of December of this year, but it's really, I just saw a complaint the other day that actually recited the Trademark Modernization Act as one of their counts. It felt a little premature, but it's but the judge who issued an order actually referenced it. So Trademark Modernization Act it's going to crack down a little bit on some dead wood, fraudulent filings, things like that. There's a whole host of other benefits it affords to trademark owners in disputes in federal courts as well. But as far as the office, there should be some added efficiencies. Obviously, there's some legislation. It's legislation. But I don't know that it's lobbying in the same way that you get with the FDA. I've had very wealthy clients say to me, well, can't we just do something to make this go faster and get approval
Right.
sooner. Like, no, it doesn't matter who you are.
Right.
And honestly, you're more likely to get bounced on a technical refusal if you keep, hemming and
Pushing
hawing.
it.
So, yeah.
Fair enough. So, as you know, we can keep going, but we're already at 45 minutes. I'm going to ask you, as usual, my 4 questions. The first question I've been asking the whole time through, but how can people reach you best?
My email, ccampbell@dwaynemorris.com. Email's best. I have threatened to put up an out-of-office message that says your email will be answered in the order in which it was received. And right now it's looking like November 2022 is good. You're now 356th in line. And no, I do answer emails. I'm not good with LinkedIn messaging, as you know.
Fair enough. Next question. What would you like to ask the audience?
I was thinking about this because every time you ask me, I kind of struggle to come up with something, but I'd like to know, it's a little off topic, but like, what's something positive that came out of pandemic life and working from home?
I think the working from home.
Yeah. I would agree. I would say that, and so many things that stem from that are what was the best thing to come out of it.
I would add one more thing, which was really interesting to me. I remember in the pre-pandemic life, in the before times, as they say, there's this. I remember that California, we used to make a whole big deal about how people in California, especially, I think it used to be generally perceived as young white women would refuse to get the vaccine for their kids. And that was a whole thing, and we can't believe that that's happening. What was really interesting to me is what the pandemic sort of demonstrated, which is that's not just the only population. There's an entire other population. It's a totally different set of vaccines, but they don't fit into that category. They will also refuse the vaccinations, which I think was just an interesting. Ignorance is on both sides of the aisle, which is always useful to know.
Yeah, it's interesting. I hear things from both sides, and sometimes I'm like, if that was true, it's convincing. If that was true, that's convincing. And it's like, why can't everyone just be honest? Because then we can make a decision for ourselves, But everything's stupid.
Here's Janan's response. The pandemic provided a chance to see what was truly important rather than the many things that were required. I like that, actually.
I like that a lot.
So next question. What is something you learned in the last month?
I coach pre-K soccer, which is 4 and 5-year-olds. And I learned how to, I have, my kids run the gamut. I've got kids that are afraid to participate. Some of them are so young, they haven't really been exposed to many people because of the pandemic. I learned how to bring them all together and get them engaged and focus on me for a solid hour. And I have 2 kids of my own that don't listen to me for 3 seconds. So I took a coaching clinic and learned how. I'm not trained in this. I deal with clients all the time. They're sophisticated. I wouldn't say their attention span's any better, but dealing with 4 and 5-year-olds, there's a lot of similarities in herding those cats. But I learned a lot of tips and tricks for getting them engaged and getting everyone to have fun and get involved.
What is one tip, just so we can take that away?
Keep them moving. Keep everybody moving. Don't do any activities that involve somebody waiting in line. So I think, I can apply that to my team as well. When we do document meetings, I often have there'll be a long period of time where one particular team member is not necessarily engaged. So I need to throw out questions and say, okay, everybody's engaged all the time.
That's a great tip. Last question. What is something that made you happy in the last week?
My kids and their soccer games, scoring goals.
That's awesome. That is really, really cool.
Oh, and I got a one playing golf with clients. I'm a terrible golfer. Went to one of the most elite golf courses in the country. And long story short, it was the closest to the pin contest. I was playing with clients. The client that went before me was within inches. So I was like, wow, what the hell? I'm not going to make it. I'm never going to get closer than he is. So just take my shot. And I literally hit the pin and got a hole in one. So
congratulations.
That made me very happy. Then I had to buy drinks for everybody at the bar afterwards.
But you get to say you've had a hole in one, which not many
I
people can say.
I do. And so people assume I'm a good golfer. I'm like, no.
Means I'm
I just
really,
got
really
lucky.
lucky.
I got lucky.
Just to remind everyone again, you can find Christine on C. Campbell at DwayneMorris.com, or you can just go to the website, DwayneMorris.com. And Christine, it was awesome having you on again. Thank you.
Thanks for having me. It was great.
And pleasure. Talk to you soon.
Thanks.